The Columbian Editorial Board is happy to welcome Bob Ferguson, State Attorney General, and Mike Webb from the Attorney General's office. Gentlemen, thank you for joining us. Just so you know, we are videotaping and recording this for use on our website.
That's fine.
And I am Greg Jane, the opinion editor here at the paper. I'll be moderating the meeting, but we'll keep it informal. And if you have any topics you want to discuss, and if anybody else wants to jump in with questions, go right ahead. So, Bob, I think we'll let you start. You said you might have a couple of items on your agenda.
Yeah, just one. I know that it was a topic in the during the campaign when I came by, and I know it came up. I think last year I was talking to a couple of your reporters. We talked about during the campaign the importance of having an open government ombudsman in the office of Attorney General, and Rob McKen had created that position, as you well know. Due to budget constraints, which all state agencies were experiencing, he had to scale it back down to a half-time position, which I know he did not want to do, but budget restrictions required it. I pledged, hey, if I got elected Attorney General, I'd do everything I could to make that a full-time position again. And had to wait till we got our budget from the legislature, but were able to do some things and move around some things in our budget to make it a full-time position again. Nancy Creer was hired. I guess now it's been, was it last year? I'm thinking. I don't want to lose track of time. Sometime middle or late last year. Last September. She used to be worked in the Public Disclosure Commission. She's an attorney. She's been great. So I don't know if you've had interaction with her directly yet or not, but just know she's there. She's working with newspapers and governments and people all across the state of Washington. So far, things are going really well. So that's been accomplished, which is great, and I'm optimistic we can keep that a full-time position moving forward, which is great. And number two was, in the last legislative session, one of my AG request bills was legislation that would require all elected officials in the state, so from AG to governor to city, county council to port commissioners, right? Any of those that level as well. There's about 5,000 or 6,000 elected officials in the state that they would all have to take training on our Open Records Act and public records issues. There have been reports that have come out that sort of one of the big challenges in getting documents out to the public that they're entitled to see is, frankly, sometimes elected officials don't know what the rules are. And that is bad on a couple levels. One, people don't get the documents they're entitled to. Number two, cost of litigation, the cost of not turning those documents over goes up as well for the local governments. So we proposed legislation to require training for all elected officials. That bill passed. Really pleased it got through in our first shot, thanks to Mike. There was one slight amendment, which you may have seen. The legislature placed an amendment exempting themselves from taking the training. So that was not our preference, but that's what was required to get it adopted.
Those rascals.
Those rascals, yeah. So, but it got passed. The governor adopted it. We're really happy. So we've been doing that training. Nancy put together a training. She does it in person. We have a video where government officials don't have to travel some great distance to get the training. It's like a 15 or 20-minute video. So it's worked out great. Many folks have taken the training, and we're really pleased that one got through, and it's been up and running. So just want to make sure, because we talked about issues of open government when I was here a couple of years ago. I want to make sure I pass that on.
Well, speaking of open government, do I have this right that elected officials, state senators, state representatives, that their schedule is not public record?
I believe that's correct. Yeah, I think that's right, yeah. That they are. I was on the King County Council for 9 years, right? That we're subject to the Public Records Act, and the legislature is treated differently from that standpoint, yeah.
Well, what the heck is going on with that?
My feeling is, this is no secret to my friends in the state legislature, that I think it'd be helpful if they're subject to the same public records requirements that the rest of us are. I think that would, in some cases, broaden their perspective on these issues if if they were subject to it as well.
I want to stay on this topic for a little
Sure,
bit.
That's fine. Yeah.
Where do they get off deciding that their schedule, what essentially their plan is, what they are doing, isn't public record? I mean, where's the rationale to that?
In terms of what's their...
What is their rationale that says you don't have to know what my schedule is? You don't have to know who I'm meeting with.
My understanding is under our Public Records Act, they're not...
I understand that.
Yeah, exactly.
But I understand that that's the Public Records Act, which, of course, they passed.
Oh, but you mean, what's their rationale for what?
How do they rationalize
it? don't ask me to defend them. I might want to be clear about that. I think they should want to be very clear where I stand on that issue. They should be subject to it, right? So I don't want to say it's better put to them, but it is better put to them, right? They're the ones who what's my opinion is they should be subject to it. In the same way that our proposal saying take the training, they exempted themselves. I mean, that's just being direct. We were not excited about that.
So that is in the law where they are exempt from the schedule.
You need a change in our state laws to have the legislature. It's not that they are somehow evading the law, right? There's no.
But isn't there an inherent problem with the idea that the people who have to change that law are the people who have made the law to say we're above this kind of thing?
I don't disagree with you on that. I mean, the law that we proposed to require the training
Can't you
had
apply
to go
any
through.
kind of pressure here?
I can assure you, my views when it comes to public records, I suspect my predecessor Rob McKenna was no different either, right? But I mean, the bill that we got passed, I mean, it on the training. I mean, to be candid, it was made clear that for this to pass, it would not have passed if the exemption had not been written into it for the state legislature. Just want to be candid about that.
Yeah.
That's no secret. That's and to the governor's credit, when he signed it into law, sometimes the governor will say a few words when signing legislation. Check out the video. He actually spoke quite forcefully at the time he signed this into law, saying, "I'm signing it, but this is," forget his exact words, but he's essentially saying, "This is ridiculous, right? That the legislature is exempt from this requirement. Why? Well, what purpose does that possibly serve?" So, I agree with you on it. Now, to be honest, it will take some leaders in the state legislature to propose that and to try and make that happen. That won't be easy for all sorts of obvious reasons you're mentioning, right? But don't ask me to defend the legislature on that one. I want to be clear. They're their clients, but on that one, I think they should make that change. I do.
By the way, did you get a chance to look at all at the Columbian this morning?
At the Columbian this morning.
Yeah.
What was that? Remind me what the headline was this morning? I'm not sure if I did.
Well, today we had a story that said the Vancouver School Board.
I didn't see this. No.
Sent us a notice of a meeting on Sunday morning.
Yep.
Sent it in at 8:30 to the school board reporter, who of course doesn't happen to be working on Sunday morning, for a meeting that they decided to schedule for Monday morning. Of course, then we had no logical advance notice to be able to get to this meeting. And by the time we even knew that a meeting existed, of course, it was long over.
Sure.
What do you think about stuff like that?
Yeah, I mean, from my standpoint, you have to have sort of effective notice to folks so that local government can be monitored. The people have the right to do that. I spent 9 years on a local government. That's an important part of the process, and this has come in many different forms, right? There's in the Seattle Times recently, they've written a lot about the Port of Seattle and the Port of Tacoma. Had a series of meetings talk about sort of joining forces on some issues. They recently announced that, but clearly there were a number of meetings that took place where the ports were meeting that were not public meetings. There was discussion about that. University of Washington, the Board of Regents, and the University President meet, I think, once a month at the University President's home. Are those open meetings or not? Is the public invited? Are they discussing business? So this comes up in many forms. In this case, hey, what's effective notice, right, to meet those obligations? I don't pretend to know what the the details of that one. What I can say is that Nancy Creer, Open Government Ombudsman, she gets exactly these kind of requests all the time and works with local government to say, hey, you are either meeting the law or you are not, and communicating clearly what my office's views are on that. So really, on a case like that, I just would encourage you, feel free to, I will pass along to Nancy, but really don't ever hesitate to have your reporter or to you pick up the phone and say, hey, Nancy, here's what's going on, send her the info. She works frequently, as Mike knows, with local governments to communicate when they're not meeting their obligations.
We'll be happy to sell you Columbian. Look at that story on the
page.
page.
On something like that, what recourse do the people or the reporters or the newspaper have if it's already passed?
After the fact, it's difficult, right? At that point, after the fact, it's difficult. There's no doubt about that, right? However, you are in violation of our Open Records Act or Public Meetings Act, right? If you are in violation, there are some things that can happen, right? But in terms of effectively, the meeting has come and gone, right? In terms of the actual,
and
what you really want.
They may have also followed technically the letter of the law.
24 hours notice or something like that.
Not
exactly.
The spirit of the law.
By doing on a Sunday morning. And,
right.
And that's the other part, that's why I need to know the details. There may be a gray area in which there may be, I don't want to speak about this one because I don't know the details, but there may need to be a conversation about changing that notice statute. If it really is 24 hours, you send it at 7 in the morning on a Sunday and the meeting's at 8 in the morning on Monday, you're right. Who's really aware of that meeting, right? So, again, I don't want to sort of weigh in on the merits legally on that, but we'd be more than happy to get my expert Nancy to take a look at it.
Okay,
Yeah. But we see, I mean, to be clear, it's exactly the type of thing that we see a lot that comes your way.
Yeah.
Yeah.
Thank you.
You bet. Yeah.
Let's move on to Hanford.
Sure.
What is the next step for the state? What can the state do to get the feds to actually make some progress on this?
So I'll try and give a relatively short answer.
But
feel free to ask follow-up questions. I mean, I know you folks have written about this, and so so as you know, my predecessor, Rob McKenna, sued the federal government back in 2008, 2009 for their failure to adequately and timely clean up Hanford. That resulted in the consent decree, right? The settlement that we have with the feds. That consent decree laid out the deadlines for cleaning up Hanford. It also gave the state tools that if we were not satisfied with the feds in terms of meeting those obligations, we could bring the feds back into federal court in the Eastern District of Washington before Judge Van Sickle.
And we're in that process.
Exactly.
Now,
So what happened was I may be off by a few weeks, but in March, I believe, of this year, earlier this year, we triggered those tools. So that first required a mediation period of like 30 days. We continued that a couple times to try and reach a resolution of having to go to court before a judge. That can be time-consuming, that can be expensive, that can be uncertain, all the things that go into litigation. We were not able to reach an agreement with the federal government, and so on October 4th, I think it was, a couple weeks ago, we did then stop the mediation process. We did not continue it, and we did file that petition with the federal court on October 4th. So that now has been filed with the court in the Eastern District of Washington. We're back before Judge Van Sickle. We're now trying to lay out a court schedule where hopefully we can move this reasonably quickly to get before Judge Van Sickle to get some relief before the judge. All that said, so that's like status, right? That we now are in litigation posture with the federal government. A decision I certainly don't take lightly, but I fully support the governor's decision to do that. Also want to be clear, we have clients here, right? The governor is the client, Department of Ecology. They make the ultimate calls on whether or not to file a lawsuit or to settle. But I can certainly say that I support the decision to initiate the litigation. Speaking candidly, you've had a lot of meetings, obviously, on this topic, and I just have not been impressed in my relatively short time as Attorney General. I can't say I've been terribly impressed with the federal government's response to the cleanup at Hanford, given the seriousness of the situation there. And I hear the challenges they have about technology. I hear the challenges on the budget, but I'm sorry. It's there's no more important issue they face in getting that place cleaned up. And it's their responsibility, and they've got to get it done. If it needs more resources, it needs more resources. So I think it was the right move for the governor to initiate the litigation against the feds.
So if it goes to litigation again, how can we make sure that anything changes? So the courts tell the feds, you need to do this, and they ignore it for a couple of years, and we wind up back in court.
So a couple things, and that is a challenge, to be candid, right? And believe me, there's zero doubt that at some point in the future, you or your successors will be sitting down with my successor talking about Hanford. There's just no doubt in my mind about that. That said, there are some things we're seeking in this petition that will hopefully address that issue, because you're right. If the feds just don't act, they don't act. But a couple things. Number one, a court has certain powers, right? Just like we see with McCleary, which we may get to later on, right? A court can hold a party in contempt, can issue sanctions. They have that power, right? That's no small thing to move action. We're seeing that in a different context with McCleary in education. There's that. In addition, the waste treatment plant construction obviously is being delayed. We have a couple dozen single shell tanks that are leakers, right? I think altogether we have about 134 single shell tanks. I may be off, but about that number, of which a couple dozen are leakers, right? Obviously, we're very anxious to get those in a more stable situation. That's what the whole waste treatment plant is all about. If the treatment plant's delayed, we are seeking the construction of double shell tanks so that the waste can be pumped from the single shell tanks, those leakers, into a stable environment while the treatment plant is constructed. That's something we don't have right now that we can seek as a result of this litigation to get the court to require the federal government to construct those double shell tanks. Something we can, the feds don't want to do. Those are expensive, very expensive, something they don't want to do. The other thing, to address your point about, how do we avoid just falling to this cycle again? There's no sure thing on that. I want to be direct about that, right? I can't guarantee, you can't force somebody to do something. That said, one thing we are seeking is for each of the deadlines that will be set, and deadlines will have to be moved. There's no doubt about that. But having not just a handful of deadlines out in the future, but a whole series of benchmarks leading up to each of those deadlines by which they have to report back to us and to the court, have you met these initial benchmarks leading up to a deadline. So we have more advance notice when a ultimate deadline is not going to be met, and we have the ability to then get back before a judge again, back before the court, and ask the court to do something. So 3 things, right? More benchmarks. Number 2, double shell tanks. And number 3, we can ask the court to use the power of the court in whatever way that court feels is appropriate to send a message to the federal government that the court is not happy with what's going on in Hanford.
But then, what would the penalty be for the federal government?
That remains to be seen, right? I mean, that's the court has broad powers to punish the federal government if the court decides to take that action. But I think those double shell tanks are important. I'm glad that the governor sought to put that into the petition, the construction of those double shell tanks. I think that's going to be an important piece of this moving forward.
Now, on something like that, does it make your guys' job harder or easier, given the fact that federal government turns over every 4 or 8 years?
New secretaries, right?
Yeah.
I mean, it's
Is it starting from scratch again in 2 years with the new administration?
It's a fair question, and I'm not sure if I'd go quite as far as say it's starting from scratch, but a new administration, new secretary, new relationship, right? So I guess I'm not quite sure I'd go as far as say starting from scratch, but it's not a fluid transition, I think, by any stretch of the imagination, and I think we've seen that in my feeling with Secretary Moniz. I mean, it's new person comes on and needs to get to speed, and things have to happen, new team, and that's a part of this cycle, I think, that I'm referring to. And one area of stability in this process, frankly, is within the AG's office. Our team of attorneys have been very stable. We have Mary Sue Wilson, Andy Fitz. These are attorneys who've been working on this for many, many years. We're actually losing Mary Sue Wilson. She's been appointed by the governor to the Thurston County Superior Court bench. A credit to her and to our agency, but she's very, very knowledgeable, head of my ecology division. But we've had a lot of stability in our office, which has helped us over all these years with the legal team in place. But I think your point's well taken. Now, with the new administration, there is always that danger, which is why, frankly, I think it was the right decision to get before Judge Van Sickle and see if he can help move the federal government in a way that we did. This consent decree, I think, was entered into in 2010. Yeah. I mean, these deadlines were just 4 years ago, right? And already it's clear they're going to be met. So it's frustrating in the extreme. I want to be candid about that.
Mm-hmm. Is that the defense? It's technology and money?
That we'll see what their responsive papers are, but what we have heard is technology is, in their view, a driver on this, and that there is some limitation on resources. Now, what they'll actually put in their pleadings before the court, we'll see. But I'd be surprised if that did not include, if what they put before the judge, I'm sure will include, hey, from a technology standpoint, we ran into complications. I understand those concerns, but in our view, that's not the whole story and does not explain all the delays by any stretch of the imagination. Yeah.
And what is the timetable for this? When will the judge be looking at that?
So we are trying to work with the feds right now to establish an actual schedule by which motions will be filed and then a hearing before the judge. So I can't give you I think we're still, last time I checked a couple days ago, we were still negotiating that. But our hope, I think the schedule that I saw that was proposed, I hope I get this right, was having us in front of the judge in the first quarter of next year, where things would be filed and you'd be before the judge. Hope I didn't get that wrong, but if you want that date of what we're trying to do, I'd be happy to track it down. But my recollection was we're trying to get before the judge in the first quarter of next year. Now, hey, this is a complicated case, and federal judges have a lot on their plate, and but that's our hope.
Yeah. Any other questions on Hanford? Let's move along to legalized marijuana.
Mm-hmm.
Correct me if I'm wrong, but I believe it's your office determined that the law as written gave individual jurisdictions the ability to not legalize marijuana.
A slight change. That marijuana is legal around the state,
right?
But that we were asked to give a legal opinion by Liquor Control Board. Asked for a formal opinion. My formal opinion says local jurisdictions do not have to sell marijuana if they don't want to. Just like in Colorado, they don't have to.
Sure.
And that was my interpretation of the initiative itself.
Okay.
Yeah.
And I believe at the time you said that if they had changed one sentence,
it's true, and that's no exaggeration. I'll just speak about it just briefly. It's
sure.
So under our state laws and Supreme Court decisions, there's broad discretion given to local governments to set ordinances and laws as they see appropriate. That makes sense. They're the government closest to the people. There's an exception to that, and that's if the state, through the legislature or through the people, through the initiative process, preempt that usual authority. And that exception is if the state says, hey, local jurisdictions, you must do X or you can't do Y. But the courts have been clear, it's got to be explicit. You can't sort of read that in or infer that because you've got those normal powers for local government. It's got to be very explicit. I've read that initiative. I've read it more than once. My team has. That language just isn't there. So I want to be clear. A sentence that's, I'm not making up, I mean, literally they had said all jurisdictions must provide for the sale of marijuana. Okay, that would do it. It doesn't have to be some overly legalese language, right? A single declarative sentence would have done it. And that language isn't there. I want to say in giving a legal opinion like that, I'm very much aware there are policy implications from that decision, right? Hey, you could have a patchwork effect where some jurisdictions are in, some are out. Is that good for eliminating the black market? I hear all that and I understand that. But in issuing a legal opinion, my job is to issue a legal opinion, right, on what the voters vote on, not what I wish the law was or what I think the law should be. And in my view, I think it's fairly clear that that language just isn't there. We've got now 4 legal challenges to that around the state. Wenatchee, Fife, Pierce County, and Kennewick, I think, are the 4, if I get them all right there. Fife has already heard it, and Wenatchee is scheduled for this Friday. In Fife, as you probably know, not only did the local jurisdiction argue, hey, the initiative does not require us to sell marijuana, their alternative argument was, if it does require us to sell marijuana, then federal law preempts the state law. So just want to be clear is that for those who say local jurisdictions should be required to sell marijuana, that will inevitably lead to a decision on whether or not federal law preempts the state law. And if a court reaches that and concludes federal law does preempt state law, which is not a, let me just say, preemption issues are notoriously tricky from a legal standpoint and challenging. There is no slam dunk on either side on that issue. I want to be really candid about that. So in the Fife case, because the judge ruled that Fife did not have to sell marijuana, the judge did not have to reach the federal preemption argument. But that's not to say that a different court wouldn't rule differently.
So in those cases, so Fife had not allowed the sale of marijuana, and somebody challenged that.
Exactly. A business owner sued saying, hey, Fife, I should be able to sell marijuana. That's happened in Wenatchee, Kennewick, and Pierce County as well. I think the only of those 4 jurisdictions, only Fife and Pierce County are arguing, in addition to the we don't have to sell marijuana, they're also arguing the federal preemption as an alternative argument. In Wenatchee and Kennewick, I don't believe those local governments are also arguing federal preemption. They're just arguing that the state law does not preempt the local. They're arguing that the state law does not preempt the local law.
And there's not been a decision in the Pierce County?
That's correct.
Okay.
I'm not sure if there's a. Do you know if there's a hearing date on that one? I don't think there's a hearing date scheduled yet in Pierce County. So in Fife, the judge ruled. Just to let you know where I see this going, that case will be appealed. The judge had to type a few loose ends on other issues that were not really central to the case before it's sort of ready for appeal. I would not be surprised. Typically, a case would go through the State Court of Appeals and then to the State Supreme Court. On occasion, appeals go directly to the State Supreme Court. If the State Supreme Court feels it's a case of great significance or it needs some attention, it would not surprise me if this is that kind of a case, that where the Supreme Court would take it directly, bypass the Court of Appeals. If that was to happen, it's possible the State Supreme Court could be hearing a case like Fife as early as the first part of next year. So, so we intervene. So we are not a party to any of those litigations, but we have intervened in those. So we've now become a party as a result. And so our views are 2. 1, local jurisdictions can opt out. Number 2, if they can't opt out, federal law does not preempt state law. My job is to uphold the will of the voters and uphold the initiative. So we're taking a strong view on that opposition to federal preemption.
And if it does come down to the question of federal law, you aren't willing to venture a guess on?
I can tell you I've spent a lot of personal time looking at that issue from the first day I took office. Because really, as you know, last year there was the potential, after the initiative was adopted, that the feds would come in and try and stop Washington State or stop Colorado from moving forward with legalization of marijuana. I went back to meet with Eric Holder, with the governor, to say, hey, we're going to defend the will of the voters. Let's avoid a lawsuit. But that was uncertain. There was a lot of thought there might be a lawsuit about that. So our team has been preparing for this for a long, long time. And I mean, you'll understand why I don't want to start in the details. All I will say is preemption issues of federal and state law can be very tricky, very complicated. It's not a slam dunk either way.
Well, they are tricky and complicated, as most things in courts. But generally speaking, isn't it true that federal law trumps state law?
So if it's in certain areas. So, for example, if federal law has what they say occupied the field of a certain area, then it can trump the state law. So one could argue, for example, hey, federal law has, let's just take it slightly out of the marijuana context, but federal law has preempted the field on drug enforcement of some kind, right? Or, well, that would be an argument that could be made. There are exceptions to that, so we'll have to see how that plays out. But let me put it this way. I mean, if we eventually get to where the courts are looking at whether federal law preempts state law, in my view, and speaking of someone whose job is to uphold the initiative, that's a serious threat to the legalization of marijuana in Washington State.
Right.
That's a serious threat. Yep. Yeah.
I mean, there are countless examples in our
Yes.
history where
You're
the
correct.
federal government has come in and,
Yep.
you know, civil injustices,
Mhm.
you know, hey, those laws clearly adversely impact somebody's inalienable
Yep.
right. I don't care what your state law
Yep.
says, it's out.
Exactly.
And so we know that exists.
Yes.
And okay, so it's fair to say that, yeah, if it gets to that, I guess your words, potentially a serious threat to the law.
I wouldn't even take out the budget. It is a serious threat to the law at that point, because if federal preemption is held,
Yeah.
effectively the initiative is wiped out. So it is. I mentioned that for a lot of reasons. One, because it's real. Number two is I think there has been a bit of a sense in the state of, okay, hey, the feds didn't come in and try and stop us right away, and therefore smooth sailing, right?
Yeah.
From a legal standpoint, not necessarily so. And number two, a new administration in 2016 could have an entirely different view about what Colorado and Washington, maybe Oregon, are doing as well across the border. And so, hey, my job is to do everything I can to uphold the will of the voters. I want to be very clear about that. That's my job. But those are both potential threats for sure. The legal one, I think, being the most immediate that's before us right now. Yeah.
So no one would come to you in advance to say to you, hey, look, you know, we've got this thing hopping around, no pun intended. We've got this thing hopping around about potentially legalizing marijuana in the state of Washington. Do you have any advice as to whether we ought to move forward with this based on the idea that the feds may put the hammer down? Does anybody come to you before the fact and ask you that?
You mean about marijuana specifically?
Yeah.
Yeah. Well, sure. I mean, we receive. We give legal advice to all of our clients, and you can imagine many of our clients have issues that touch on marijuana. Just speaking hypothetically for a moment, let's say there's a state agency that receives federal funds for something, whatever it is, the work that they do. Federal funds are typically contingent upon following federal law, right? Well, you know, you've got complications, right? Let's say you're a state university. You've got students on campus, right? How are you?
Right.
You get federal funds. How are you handling that, right? So it's a big body of work for us to advise our clients. One issue I think all of this will highlight that won't be news to you, but is one that I think is, of all the issues facing us within marijuana legalization, besides what we've already talked about, just upholding the initiative, right, which is obviously central. The issue related to the banking industry and trying to avoid a cash industry with the sale of marijuana in storefronts is really important, critically important, I'd say. And obviously, federal law says those are the sales of illegal proceeds of an illegal drug transaction. You're in violation of federal law if you're a bank taking those proceeds. But we want to avoid a cash industry. We've had a lot of conversations with the U.S. attorneys in the Eastern District of Washington, Western District of Washington. But hey, how are we going to navigate this? Because we all agree, whatever you think of marijuana legalization, you don't want to have a cash industry, right, from a public safety standpoint. Colorado's had some real struggles. That's going to require a change in federal law. There have been proposals to do that, one of which got through the House of Representatives but did not get through the Senate. So there's been some progress there. I can't say I'm holding my breath on a change happening at the federal level, but that's what it really will require in order to give some more certainty with the banking industry specifically. Yeah.
It's not happening in this state, but do you get much about internet gambling? Any discussion in the state of Washington about that?
Do we get? I mean, I can't tell. Ask Mike if you hear much on the legislative. Not much has come to me directly on that. To be candid, that doesn't mean there aren't conversations going on. But it hasn't come to my level of.
Certainly, a couple of states have. Have dipped their toes in here,
Yes.
and of course, we all know from a federal standpoint that I guess theoretically illegal, but it was proliferating until until the federal government sort of put the hammer down on that as well. So now they're moving through various states like Nevada, for example. but as far as you know, it's not on anybody's radar here in the state of Washington.
I don't say it's not any. It hasn't risen to my level. I mean, I'm sure it's on the radar of other folks, but it hasn't come directly to me on that.
Do you have an opinion on that?
I guess I'd want to take a look. Hey, what exact? We have policymakers who set who set those things. I'm always mindful of my role, right, and trying to get ahead of the policymakers. They want to seek legal advice about what the implications are. We're happy to provide it. And one more thing on marijuana before I forget, I did just want to at least mention briefly on edibles, marijuana-infused edibles, cookies, candy bars. Washington's moved a bit slower than Colorado on the rollout of legalization, which has bothered some folks who want us to move quicker. To be candid, it has not bothered me too much. I'd rather sort of get it right than be first. And edibles is a good example where Colorado has now turned to us for some guidance on how to handle edibles, specifically around cookies. And in Colorado, they had some really tragic circumstances around marijuana-infused edibles. You may have read about, with a marijuana-infused cookie, you are not supposed to consume the entire cookie, right? Which may be counterintuitive to folks, but the amount of marijuana you do not want an entire cookie. Maureen Dowd wrote an article about her experience inadvertently consuming a whole cookie, not realizing you weren't supposed to do that, and she had a fairly described as a traumatic experience as a result of what she went. Read it if you haven't had a chance. It's actually interesting to read. She wrote that several months ago. In Colorado, I think it was a college student consumed an entire marijuana cookie or cookies, was hallucinating and jumped out of a window and killed himself. So there have been some real tragedies, and I think a sense in Colorado there were not enough clear descriptions on the packaging of the marijuana-infused edibles. And that's not the only situation they had in Colorado. But so in Washington, our Liquor Control Board, we've worked closely with them to make sure the packaging of marijuana-infused edibles do a couple things. One, make very clear how much is an appropriate amount to consume. And number two, make sure that packaging does not appeal to kids like my 6-year-old twins who, if they see a candy bar or a cookie, they know what to do, right? Consume it. And so the Liquor Control Board has passed a number of requirements around that. So, for example, the packaging has to be approved specifically by the Liquor Control Board. Mike was actually just mentioning this morning. We can get the details if you want. Apparently, there's been a legal challenge to at least one of those.
Because they also have to approve the product, whether it's cotton candy or a lollipop. It's not supposed to be a product that's especially appealing to children either. And so they denied an application to do a marijuana-infused chocolate bar, and that person has appealed that decision.
Mm-hmm. So there will be litigation even around that, even around that world of marijuana implementation. There will be litigation around that.
Now, were those
I've got a 1:30.
No problem. Great to see you. Yeah, thanks so much.
Now, were those limitations written into the original law, or have they kind of been make it up as you go along?
So marijuana-infused edibles were allowed under the initiative, and then the Liquor Control Board, of course, as you know, with many aspects of our initiative, were tasked with creating the rules and regulatory system around that. That included edibles, so they were empowered to create rules around edibles, which they've done. Yeah. So, but now whether or not the legal issue is whether or not the use of that discretion or that regulatory authority is appropriate in this case is what's being. Now, I've not seen it yet. Mike just mentioned the car ride down that happened, so I'll be looking forward to talking to my legal team about that. But apparently, this just happened. If you're curious about that, we're happy to get more details about it. But that's a type of important, litigation that will set the parameters of what the Liquor Control Board can do under the initiative.
And one more question about marijuana. And now, getting back to the issue of jurisdictions being able not to sell. Is that something the legislature could address?
Thanks for
Can they go
mentioning that.
in and pass a bill and add one sentence to the law?
I'm glad you mentioned that. That's an important point. So as much as my job is not to look at the policy implications of whether jurisdictions can opt out, we do have policymakers who can change that. So you're right, the state legislature can. It's been 2 years now since the initiative was approved, so by a simple majority vote, they can amend or clarify the initiative. And there was a proposal last year.
I understand there will be this year too. I mean, to be fair,
to require jurisdictions to sell marijuana.
Mm-hmm. Right, to require, to prohibit the opting out of the system. But if you do that, you might well be inviting lawsuits from the governments. Fife now might sue to say I shouldn't have to do this because
federal law would preempt state law.
Right.
So that is one. Let me put it this way: for those who support the legalization of marijuana and want to keep it in Washington State, it may seem counterintuitive. But allowing jurisdictions to opt out, which happened in Colorado, and which, by the way, in Oregon, the way they've written their initiative allows an opt-out provision, that does avoid the federal preemption argument, right? By definition, avoids that because you've got that ability to opt out. A hard line on saying, no, everybody must provide for the sale of marijuana does not merely invite that federal preemption argument; it makes it inevitable. So that is just, I just point that out there for the, for the sake of conversation. But the policymakers, legislature absolutely do have the authority, and Mike's right. There will be a bill to do that. Whether or not it passes, I don't have an answer for you on that. But it wouldn't shock me if it passed. I mean, there was some momentum even last session about it, or is that going too far?
It would surprise me.
It would surprise you. Okay, he's the expert, so yeah.
Interesting. Let's move on to McCleary.
Sure.
And for someone like me, a novice, how unusual is it for the Supreme Court to retain jurisdiction? In a
Unusual.
Case? Okay.
Yeah.
What was the foundation for that?
Well, the foundation was simply they wanted to make sure that the state was meeting the requirements of their order in the McCleary case to fully fund education, and ask for periodic updates, as you know from the legislature, periodic reports. Our role, of course, as lawyers for the legislature, right? We sit down with both parties and try and craft a report. One thing I've tried to do is ensure that it's one report that goes to the court, not a Republican report and a Democratic report, which has been kind of challenging, but I really appreciate both leaders in both parties have come together despite their differences on many respects about education funding and how to fund it. We have issued each time one report from the legislature to the court. And just in general, where you have the court involved in a case with the state legislature on a budget issue, retained jurisdiction, that is, as far as we know, first of its kind. Doesn't mean somewhere back in the history of our state, but we've done a lot of research on that, as you might imagine. We're not aware of a situation like this in Washington State. It has arisen in a couple other cases. A couple other states. Kansas and New Jersey, I think, had very similar situations with very different outcomes. I think in Kansas, they actually end up making the funding. In New Jersey, the legislature frankly just ignored the Supreme Court in that state. That's there's been different reactions.
I mean, is there any legal foundation to the idea that the courts have stuck their nose too far into the legislative business?
I mean, it's. I want to be careful about how I answer that question, obviously, because my lawyers are appearing before the court on this and will in the future, and so what I can say is it's uncharted territory for sure, what we've tried to do is we recently had the hearing around whether or not the legislature, the state should be held in contempt, and then if so, whether there should be sanctions attached to it. Right? We argued that there should not be a contempt finding, and there should not be sanctions. The court, as you know, said, "State, you're in contempt," but did not issue sanctions, which I think was a reasonable outcome, to be honest with you. Right? I'm not sure the issuing of sanctions would have actually helped get us all to the place we all want to get. I'm the son of a public school teacher, right? She's retired now, but hey, I want full funding of education for kids in our state, as does everybody at this table, and I think everybody in the state legislature. We got to get there, right? And I don't find fault with the court's decision, right? And hey, do I understand sort of the larger constitutional arguments? Hey, whether the court rather should be involved in this? The bottom line is they are. They've issued some orders. It's the responsibility of our client to follow those orders, and it's our job to represent them.
Well, but is there any recourse for the state legislature? And I don't know what's happened in New Jersey, because I think, as you said, they just said.
I think they just ignored it.
Thanks for the information. Yep. See you later.
That's correct.
But I'm trying to figure out where the recourse is, maybe on either side. I mean, let's assume that we go the route of New Jersey, and the state legislature says ain't going to happen. Mm-hmm. What's the recourse for the court system?
Right. So first, I don't think that's going to happen. I mean, I want to be clear about that. I don't think that's going to happen. I'm not a member of the legislature, but I think the legislature. I mean, hey, they put in $1 billion or $1.5 billion to education so far. Yeah. They are reasonably on pace to get to that. Yeah. The many billions they need to invest. Now, this upcoming legislative session is a huge one, right? I mean, they've got to come up with a significant investment in this upcoming session. No two ways around that, right? So the proof will be in the pudding when we get through the next legislative session. So I just don't think we'll get to that point. I think.
But for the sake of argument, theoretically,
taking this out in a theoretical world, I mean, the court has all sorts of power if they feel someone's in contempt, right, of a court order.
And in fact, they sat here several months ago, and the Supreme Court did, mm-hmm. and I asked, well, what are you going to do? Throw them in the Who Scout?
Right.
Well, theoretically, they could,
Mhm.
I guess, identify a few people and
Mhm.
throw them in the Who Scout.
Mhm.
But in this quagmire that exists, I mean, if it gets there, I mean, does the state legislature have any recourse? And oh, by the way, if there is this legal fight between the state legislature and the Supreme Court, where do you land? Who do you represent?
Our client's clear. We represent the state. The legislature is our client. So
Okay.
Alan Copsey is one of my attorneys in the Solicitor General's office. He was in there arguing when we had that hearing last month. He's in there. They're our client. That's our
So
job.
theoretically, you potentially could end up defending the state legislature against the state Supreme Court.
I don't really think it's being against the court. I mean, there's a
Well-
there's a court order. If the court, hey, to be candid, this happens around the state all the time. Courts have our attorneys come in because the client's in some difficulty with the court, not following court order. Our attorneys go in there and defend our client, right? Wherever that might be. That happens all the time. To be candid, this one is a very high profile one, right? But that is not an unusual circumstance that a court's not happy with one of our clients on
Right.
something, and our attorney's there to represent our clients. We do that, and tough cases, easy cases. That's our
Okay, so
our role. Yeah.
You'd end up representing the state legislature
They're our
against
client.
the Supreme Court because they're your client.
I just want to be clear. It's not against the Supreme Court, right? That's not the way. I guess I just want to be clear. I don't view it as that. Well,
What word would you use other than against?
Well, I mean, I guess from my standpoint, the legislature has a job to do, which is fulfill a court order, right? That's their job. And there are plaintiffs in the case who have sued the state. It's not the court, right?
Yeah.
Plaintiffs sued the state. So the plaintiffs are contrary to the state in this case, right? Parents of school children, right? It's not the court. The court is making a decision. They implement that order, but it's the plaintiffs who sued the state, and that's where the lawsuit arose. The court didn't just wake up one morning and decide, hey, they're going to take on the state legislature on funding. There was litigation around that, right? So,
Okay.
but I hope you understand. I'm not going too much on hypotheticals, right? I do, and I mean this sincerely. I do think the legislature will meet its obligation. I do believe that's going to happen, and I think they've received the message from the state Supreme Court, and I think the court was wise not to issue sanctions. I think that was the right. In some respect, I won't quite say they had to find them in contempt, but the state was violating a court order. That court order was, as you recall, was to establish a funding plan, right, in the last legislative session. They did not do that, right? There's no debate about that. So the fact that the court held them in contempt was not a surprise. And I think the sort of a big part of the decision was whether they would issue sanctions and what would those sanctions be. And the court said, hey, we're not going to issue sanctions now, but they made it clear I think literally the day after the session ends, we want to report on the funding and what happened. So happy to take the question when it's no longer a hypothetical, if it's no longer a hypothetical next year after the session. But I do think I think everybody recognizes they've got to meet that obligation.
But if the legislature decides that, hey, the court has overstepped its bounds, where would the legislature go? Does it go to a different court? Do they just ignore it if they decide?
To be honest, a hypothetical. I'm just not going to go down to hypotheticals. I hope you understand me, right? There's what I can say is in Kansas, we have two other states in Kansas. My understanding is the legislature ultimately largely met the funding requirements. In New Jersey, the state legislature did not, and it's my understanding the Supreme Court stopped issuing orders at some point.
We took our best shot. Okay.
Yeah. So I can't answer that. I just don't know the answer to that. I just don't think it'll come to that point. I just really don't. I think reasonable minds will prevail. I think folks want to fully fund education. Do I think that'll be a big challenge? You bet. Right. I don't want to understate the significant challenge that will be for the legislature and the governor, but I think they'll do it. Yeah.
Well, I'm looking at this initiative that's on the ballot, the statewide initiative that's on the ballot to reduce classroom sizes, which some people suggest might throw another $10 billion into the mix. And,
Right.
On the off chance that thing passes, and then all of a sudden what? The legislature has got Cleary that they have to look at, and this thing that they have to look at, and the concept or the theory that they're going to fund both of those things. At some point, the legislature would then, I think, throw up their hands and say, it's out of control.
I will leave that one for the state legislators who have to make those tough decisions. How's that? Yeah.
Okay.
I've got enough challenges on my plate as they are. Yeah. So yeah.
Okay. Well,
Yeah.
that would be a fun TV show. To
Yes,
watch.
indeed. Yeah.
Changing topics,
Yeah.
relative to your predecessor, how are you doing with taxpayers' dollars? Are you growing the AG's office, shrinking it? Staying about the same?
It's about the same since I took office, for sure. The office overall since 2009, I think, we have about 150 fewer FTEs. That's just sort of been a gradual with budget cuts that all agencies have. And a lot of that, as you might imagine, happened right during that recession when it really hit. Things have scaled down. So we are, I think when I took office, we had 525 attorneys. We have, last time I checked, basically that same number. That hasn't changed. If you want the exact number, more than happy to get it for you. If you want sort of a year by year, we've got all that data. But no, there's not been a significant changes in the last year, for example. But the budget is, in terms of total FTEs in the last handful of years, it's a smaller operation than it was before. So, for example, the Solicitor General's office, for example, is like 27% smaller. Solicitor General's office
no less work, obviously.
does no less work. I mean, they argue the appeals before the state Supreme Court and through the federal courts. And the biggest cases, that's Solicitor General's office. They're 27% smaller than they were in 2008 or 2009. So, but that's I'm not complaining. That's hey, we're all in together. In fact, I just sent in my. We have a salary board. I'm not getting the word right, but there's a salary commission that sets salaries for elected officials. I'm asked to give an update on the work in the office, and if I'm asking for a raise, for example, and I put in there, no, I'm not asking for a raise. Please don't give me one. We have folks in our office who have not received a COLA in a number of years. So it's lean times for all state agencies. Again, I'm not want to be viewed as complaining about that's just the reality we've got. But budget conversations are a big part of our weekly core leadership team meetings about how we're going to manage our budget here and still get the work done that frankly everybody expects us to do. Yeah. And as you know, most of our budgets you probably know is actually put in our clients' hands essentially, and then we bill to our clients for legal work that we do. So we don't receive that much general fund support. Most of it goes to our clients, and then we bill the Department of Corrections, and they get their funds for legal services from the legislature, and we bill them for it. So that's the bulk of our funds. When I say our funds, the bulk of the funding for our office, rather, comes that way. But if you actually, we'd be more than happy to provide you whatever information you want about the office budget, number of employees. We'd be happy to do that.
Or you can have any big asks of the legislature here?
In terms of budget or in terms of AG? Well, yeah, I mean, with the budget, we've had, I guess there'd be a couple things I'd say about it. One is we've had, as I mentioned, many of our employees and our professional staff have not received COLAs, and they're not unique. I mean, state employees generally, how long has it been?
6 years?
6 years without a COLA. That's a long time. And so we are certainly advocating for a COLA for those employees. And our lawyers have been, this has been in fact, one of the first things when I got elected was, I think it was even before I took office, Rob and I co-wrote a letter to the OFM after I got elected because the attorney salaries had been frozen for 5 or 6 years. So when I took office, a first-year attorney was making $50,000 a year. In fact, their salaries had gone in reverse because there was a 3% reduction that took place in 2010. I'm kind of forgetting the year. So their salaries all had gone down. So we had a situation where a first-year attorney made $50,000 and a fifth-year attorney in our office made $50,000 because salaries have been frozen for 5 years.
Well, that sounds like you're making less than some teachers.
So I can assure you, compared to lawyers, and I'm not comparing to private counsel or in private firms, we all realize we don't expect that. But Rob McKenna done a study of public law firms, county prosecutors, city attorneys, and of the 12 or 13 he studied in 2011, I think it was, we ranked dead last. And to be, clear, like dead last, like by a ways. I'm not comparing to just King County. You cross the state. We lost an attorney last year who went to go work for Cowlitz County, and she received a $21,000 pay raise to go work for Cowlitz County for work that she said was less interesting and less demanding, but it was $21,000 bucks, right? So thankfully, we've had requests to the legislature since I got started in office to address that issue, which we have huge turn. You don't want to hear my sob story, but since you asked, stop me whenever you want. You got me going. But our attrition rate with our attorneys have been around 15, 16% now for some time. And they're leaving, by the way, not so much to go to private law firms, but to go to the city and county prosecutors or attorney's office, and also to our clients. Our clients hire them to come on board, not to serve specifically as an attorney, but come on staff. They bring them on board and they get a pay raise to go work for a client. In some cases, significant pay raises. So it's been a huge problem. As a long story short, the legislature, we had an ask of, I think it was, help me out, $7 million bucks, of $7 million bucks to get us to at least comparable with our public law firms around the state. The legislature, which I greatly appreciate, gave us $3.4 million last year, half of that, which we really appreciate, which has gone a long ways to, as you might imagine. There is another half to that request, which we realize tough budget times, we get that, but we are making that request and feel it's an appropriate one for the attorneys in the office. Like I said, they've literally gone 5 or 6 years going backwards in their salaries, and it's just, we talk about Hanford, right? We're able to, Andy Fitz, Mary Sue Wilson, I mean, their salaries were frozen for years, and they're taking on huge, and they're up, we sue large consumer protection cases, powerful interests, right? They've got attorneys who are compensated well, law firms behind them. We will lose some of our best people as a result. So, long story short, that's a request that we certainly have in the budget again. Realize that's going to be, it's tough. They've got a lot of challenges, but we really appreciate it was bipartisan support from the legislature to help us out with that need.
Have you seen any comparisons to other states around the country?
So, it's interesting. Each states are very different when it comes to AG salaries. I can't say we've done a detailed study, but I know in some, and even AG salaries themselves are very different. So what I would say is that I don't pretend to have a scientific, right? Each state is very different, as you might imagine. But our first year salary a year ago was, whenever I asked another attorney general about their attorneys, when I told them, hey, our first year and fifth year attorneys are making $50,000, that got raised eyebrows. Like, whoa, that's how you keeping people third year, the fourth year. I mean, that's tough, right? So, but we've not done, it seems like it was more comparable in-state, right, with city attorneys and county attorneys. Each state sort of different dynamics there, yeah, even with AG salaries themselves. Yeah. So my view is that I'm not asking for a salary increase until all my employees in my office have at least had a COLA is the way I'm looking at it, yeah. Don't tell my wife I'm doing that.
Any other questions?
Last thing I'll just mention, just real quick, just update on litigation, which I don't know if it certainly wasn't going on when I was here during the campaign, but I think I spoke about with your reporters last year. As you might recall, or earlier this year, we had on the ballot last year the Initiative 522. Thank you, 522, the food labeling, the GMO, the food labeling initiative, which I took no public position on, by the way. Before I go any further, I took no public position on it, and in that, for that initiative, millions of dollars spent on both sides, as you know. The ads were ubiquitous. We did an investigation during the campaign because we had reason to believe that the largest donor to the No campaign was the Grocery Manufacturers Association, the GMA. Their members, they have a couple hundred members, think Pepsi, Coca-Cola, that type of thing. They had donated, the GMA donated about $12 million to the No campaign. We had reason to believe it wasn't really from the GMA, but rather those individual members were writing checks. The GMA put them all in a fund, put it all together, and cut a check from the GMA to shield from public view the actual donors. So we did investigation, got documents where that is exactly what happened. They created a fund. They did a memo to all their members saying, we're going to create this fund to engage in the No campaign in Washington State. You're going to pay into it. We will then cut a check from the GMA. And the words literally in the memo were to better shield you from public scrutiny. That's in the memo from, I think, the executive director to the members, to better shield you from public scrutiny. They did that because in California, there had been a similar initiative the year before. Those donors were out there, and there were boycotts around some of those products, and it was a headache for them. They didn't want to go through it again. So they set about to evade Washington State campaign finance laws. On the transparency side, want to emphasize there's no limits to how much you can donate to an initiative, right? As much as you want, but you guys disclose who's writing the checks. So we did an investigation, had those documents, filed a lawsuit against them a few weeks before the election. To their credit, within like 48 hours, front page headlines, right? They turned over the names of the donors. What they have not done is agreed to pay any penalty for evading our campaign finance laws for many, many months. And so we're in Thurston County Court. They have countersued the state and me individually, saying that those campaign finance laws, again, not on limits, but on transparency, are unconstitutional. We've won our first hearing, long way to go. It's our first hurdle we got through, but it's going to be thank you. It's going to be a fight. They are well represented. My former law firm, Preston Gates Nell is now K&L Gates, represents the GMA. They have very good lawyers. It'll be a fight for sure. But we're in Thurston County Superior Court. Expect to be in the courts for a while. We'll see where it lands. But it's the largest amount of money ever concealed in a Washington State election ever by several $1 million. So it's a big, big case. And we're seeing campaign finance laws being challenged across the country in states and federal courts. limits and all sorts of things. But this is a big one because, hey, the voters created our a transparency in our elections right back in 1971, 72, and this really goes to the heart of it. So stay tuned on that.
Now, how do the laws differ in Oregon, and are they doing the same thing?
I couldn't tell you what I just don't know the answer to how they're. I just don't know the answer to how they're engaging it down there. Oh, I know it's on the ballot. Oh, marijuana, top 2 primary, the food labeling. Oh, yeah, it's.
Like
they're Washington.
Exactly. Right. So no, follow that closely. I just don't know the details of how how the funding is. I trust that they are meeting their obligations under Oregon's. I don't know what Oregon's laws are specifically around transparency, but I trust they're following those.
So you have a dollar amount as to what you're asking for?
So that's a good question. So we have not set that. First, we have to get through the challenges, right? The challenge first. If a judge finds they violated state law and upholds the state laws, the judge would then go to the penalty phase and decide, hey, what's the penalty? So we've not had to put that in writing yet. What I will say is that my view is that it can't just be the cost of doing business for these guys, right? That you can just evade our laws.
It needs to be punitive.
Exactly.
More than $1 million?
I don't want to put a dollar amount on it, but let's put it this way. I have not settled this case, right? And that's not by accident, okay?
Yeah.
Right? I've not settled this case. These cases typically settle. I'm not saying I'm not going to sell it down the road. I want to be clear, keep all my options open, but the case has been around a long time. I've made it clear to my team we're moving forward, and we're going to...
So they've put an offer on the table and you've rejected it?
Without getting into details, I've made it clear to my team that we're not in a position to talk settlement at this point. We're just moving forward. And so, and that's been communicated. So, again, don't want to preclude something down the road, but the primary reason for that is because I think it's important to uphold these laws, right?
Yeah.
And this is as good a test case as we're going to get. They said about to evade them quite intentionally.
Yeah.
We've got documentation of it.
Yeah.
And it's a large amount of money. And so it's at this point, it's my goal to uphold the constitutionality of those laws and get before a judge. And at that point, hey, judge, here's what we think it should be. But it's the largest amount by many millions of dollars, and they did it on purpose.
Yeah.
And those are factors. When a judge sets a penalty, without going too much into the details, hey, the amount withheld, whether it was intentional, those things, sophistication even of the parties can be, right?
Right.
Is this one person formed a 3-person pack and didn't quite realize versus, right? Those things can all be factors. So it's an important case, but it'll be in the courts presumably for a while. Yeah.
Right, well, interesting. Well, Bob,
Yeah.
Thank you very much.
Oh, thank you very much. No, really
Thanks
appreciate the
for
time.
joining us.
Yeah, happy to come back next time we're down here as well. Yeah, have a great day.
Appreciate it.
Yeah, thanks for
Great to see you, of course. Yeah. Great
Thanks
to
for
see you.
coming in.
I really
Nice to
appreciate
meet
it. Yeah, enjoyed it.
Thank you very
Yeah,
much.
great to
Nice
meet
meeting
you.
you.
Mike, thanks for
Thanks.